Hey everybody, hope you guys were able to enjoy the lecture last week and hope that everything's been resolved. I think last I checked, everybody was already on Blackboard except one student, but I haven't double checked to see if that person's in Blackboard. So if you're still having an issue with being logged into Blackboard, my recommendation continues being that you speak with Miss Oliver, Tere. And I again remind you guys to make sure that you stay up to week watching these lectures and with your discussions. I think somebody turned in one of their discussions late, so from the get-go, it's going to be reduced by whatever many number of days they turned it in late. All right. So I wanted to start chapter 2's lecture. So let me actually go ahead and share screen again. I want to talk about, again, we're in chapters 2 PowerPoint presentation lecture. Oh, and before I continue, I have had students ask me questions about the textbook and how they haven't been able to get the textbook. The textbook is neither required by me. I'm not making it up. It's not going to be used by me in the test. I'm going to be using primarily the PowerPoint presentations that I'm teaching and information that I also give you guys in these in these video lectures as what you guys are going to be responsible for. So you guys are not responsible for anything found in the textbook that is not in my presentation or that is not in these PowerPoint presentations. The tests and the assignments will be based off of my lectures and the PowerPoint presentations. So we've talked about already how the purpose of the Constitution as it was made was to promote freedom, liberty, and fairness, right? And these are the founding concepts, the founding principles within our Constitution. Now, if you move forward, once we have a Constitution, the next question you're going to ask yourself is, why do we have laws? What's the purpose of laws? Why do we have laws? And for those of you that have taken or are currently taking law studies with me, you've already seen how law has different purposes. And the textbook, or I should clarify, the PowerPoint presentation that we're using from the textbook that MDC uses has created 7 purposes of laws that are a little bit different from the 7 that I've already offered students in the past, but they're similar in many ways. So let's go over these, right? Law has attempted to promote 7 different goals according to this book, according to these slides. The first one is to protect society's interests, right? This means that we want to make sure that society's welfare is being promoted, that society as a whole is benefiting from laws. The second purpose, to deter or prevent antisocial behavior, meaning we want to stop behavior that hurts society, right? They're very similar, 1 and 2. The third one is enforce moral beliefs. This goes against something that many people think. We actually do promote moral values in our laws. What's changed sometimes is our understanding of what morality is, so that perhaps what people thought was moral 100 years ago is no longer what people may view moral today. However, the role of morality within our legal system remains as true today as it's ever been, in that our legal system reflects the moral values of our society in today's day and age. A fourth goal is to uphold individual rights. This means that we want to protect a person's rights, right? Whatever we define those rights as being, we want to make sure that an individual has their rights protected, and that's one of the purposes of law. Now, the fifth one is highly controversial. It supports those in power. This is a very cynical perspective of law. It has certainly been true at different moments in history, particularly as we go further and further back in history. But I wouldn't recommend it as a purpose, my opinion, necessarily today in our American society today. But there are some who believe that the role of law is to promote or to protect people who are in power and to make them more powerful. And that was certainly true at the time of kings and queens, when laws were passed to strengthen and promote kings and queens. It is also true in dictatorships like Cuba and China, where the laws are passed to make sure that those individuals who are in power remain in power. A sixth goal is to punish lawbreakers, So this is kind of dumb, but if you break a law, one of the purposes of law is to make sure that we punish you for having broken those laws. Last but not least, seek retribution for wrongdoing. What this means is to seek fairness, to seek justice if somebody is wrong. So if someone breaks your phone by accident, you have the right to sue them, and you're going to have a chance to seek whatever a fair result is for the loss of your cell phone, either in the form of receiving the dollar value of the phone at the time that it was broken. Maybe you'll request a new phone, or whatever, or maybe last that it get fixed, right? But regardless, the point is that whatever outcome you choose to pursue, whatever the outcome that the law chooses to pursue in these situations, the purpose is to try and promote a fair result, a just result, and that's what we call retribution, right? Fairness, to make sure that whatever the punishment is satisfies the wrong that was caused. If we look at criminal law, if we have a person who commits the crime of murder, well, if you believe in retribution, the concept of retribution is going to be applied. So in the sense that we are trying to promote a fair and just result for whatever issue, for whatever criminal law is broken. Okay? Now, I want to talk about social contract theory. By the way, if I skip over slides or if I don't talk about something, it means that I don't care about it and I'm not going to test you on it. So you could ignore information that I specifically go out of my way to not talk about. So social contract. Social contract theory is a very important idea that has affected or has impacted how we have created our constitution and our legal system here in the United States. The idea behind the social contract theory is that individuals, and this was invented by John Locke, and his idea was individuals have agreed to give up a small percentage of their individual freedom to society in the form of a government, so that every person within that society, every individual within that society receives added security. And this is interesting, this is controversial because we can kind of think of this as being on a continuum, meaning that on the one extreme, we have a person's complete freedom, but they don't receive security from society. So it's every man for themselves. And if someone within society tries to harm the individual is the only person responsible for protecting themselves. On the other hand, you have extreme security, but no individual rights. And what this means is, yeah, maybe society is 100% safe, but the reason that society is 100% safe is because for jaywalking, you can go to jail for life. And so the punishments within society are so extreme, and there are so many laws, and their laws are so restrictive that while there is order within society, or there may be order, individuals are in fear and they don't have freedom to live their life the way they think they should. And obviously, between those two extremes is where we want to find a correct solution to what the role of government should be in relation to an individual. Okay, and that's always the tricky part. If you live in China or Cuba, they pretty much don't give any individual freedoms. Everything is whatever the government wants, in the name, so they claim, of promoting security. If you are an anarchist, you believe in no government, and you think that your rights should be absolute 100% and that you can do whatever the hell you want without any consequences. Obviously, I think either extreme has its negatives, obviously. The question is, where within those two extremes should a government that is fair, that promotes security, but also promotes individuals' rights be located? And that's the question that we struggle with in our society, and society in general struggles with. So this is what I've talked about, right? Again, justice tries to promote individual rights on the one hand, but also the needs of society as a whole on the other hand. And that's, again, the same example that we've been talking about overall. Making sure that we promote people's individual rights, that we promote society's rights, but we also don't want a government that's too powerful, that's too harmful, that's too that exists only for the benefit of those within power. Okay. I want to talk now about common law. Okay. Common law is the same thing as case law for our purposes. For our purposes, it's the same thing. They're not exactly the same thing, but they're very similar. So you're going to see in a future slide the term case law. the definitions for case law and common law that we're going to be using for the purposes of this class and this course are basically the same. So they're interchangeable terms. What is common law? Common law is a legal system that is invented by the British and has been incorporated or adopted with every country that at some point had British rule inside of them. So the United States, right? We came from Britain. We are a common law country. India, Canada, Jamaica, the Bahamas, Australia, New Zealand, Belize, all these countries are common law legal systems because they came from the British. And so, okay, well, now we know where common law is located, which countries have common law. That still doesn't answer the basic question of what is common law. Now, common law is a legal system where judges add or make up parts of the law. Judges make up or add parts of the law. How do they do that? Well, they receive a case. They receive a case and they're told to apply the law to that particular case. And let's say that the case involves a murder. But the rule on murder may be very simple. The law on murder, as it's written out, may be very simple. And the judge wants to create an exception in this particular case. Or they want to say that in these particular cases, a murder trial should not be as bad or should not be punished as severely because of X, Y, Z reason. Well, the judge, in the interest of trying to promote more fair results, was empowered by the British king at the time, and by the British for centuries, to make those exceptions and to make those added laws. And how did they do that? They wrote what is known as an opinion, where they explained what was happening in this case, the outcome they thought was fair within the case, and how they reached the results that they reached in that case. And that judge's decision, that judge's ruling, that judge's outcome in that particular case, along with the exception that they created in that case, became, over time, common law. Other judges read it, other judges approved of it, other judges kept using it, and over time it became common law. It became as powerful as a law that could have been written out by the king. And so to this day in the United States, we have this common law concept where judges in the United States at both the federal level and the state level make up or add to parts of the law. And if the legislature wants to make a change to that law, that is great. However, they have to write a law, and then common law is eliminated in that particular area or changed in that particular area. And so it's also called case law because this is the law that judges make in cases. Right? You have to look at the cases to see what the case law says, what the law is, but it's also called case law because the law is literally written in cases, in documents that are known as opinions. So case law is found within cases or case opinions, right? And case opinions or legal opinions are the opinions that judges use to write out, the documents that judges use to write out their outcome where they make up or add to parts of the law in particular cases. All right. Now, stare decisis is a concept that is also very important within common law. Stare decisis means we are going to respect prior cases that judges have written case law in. In other words, the case law that has been found in previous cases, those modifications to the laws that judges have made in previous court cases are going to be very influential in similar cases in the future for judges. Future judges don't really want to change those previous cases. It's a very important concept. We call it stare decisis, meaning let the decision stand. What decision? The decision that the law made in the past on how the law needed to be modified or added in that particular example. So that if in a future example there is a similar story, a similar problem that a new future judge has to deal with, they are going to apply the case in a similar manner to how the previous judge did. All right. Now, trying to make sure that everything is running smoothly. I'm trying to see if there's anything else I need to say. I don't really care about this. I don't really care about this. Let's talk now about statutory law. There's a mosquito that I want to kill that I can't kill. So if you hear me randomly clap, it's because I'm trying to kill a mosquito. Statutory law is different from common law in that statutory law is the law that is written out. Okay, so like I told you that the judge wanted to make an addition or an exception in a common law country to whatever the law was that was written out on murder. That was the example that I used. Statutory law is the law that the lawmakers actually originally wrote out in books. And statutory law is the exact same thing as codified law. They're synonyms. They mean the exact same thing. Codified means to write out. So statutory is a fancy word for law. Statutory or codified law are laws that are written out. And when we're talking about statutory law in the United States specifically, we're talking about federal law or state law. So the law that the state of Florida has passed, the law that the United States has passed, the law that the state of Idaho has passed. Ordinances are essentially statutory law for towns, cities, and counties. Okay, so you can think of ordinances as the laws that are written out, but just at the town, city, or county law level. So an example of an ordinance would be when Mayor Jimenez imposes a curfew through an ordinance that tells everybody that they cannot be outside of their homes past 11 p.m. That's an example of an ordinance. I want to talk about Marbury versus Madison. Marbury versus Madison is perhaps the most important Supreme Court case in American history. Now, the concept and the reason that it's important is because Marbury versus Madison establishes the concept that is known as judicial review. Judicial review is the power that courts have when they're looking at the case to decide whether laws that are being used within that case are consistent with the Constitution. And if they're not consistent, then the law becomes eliminated by the judges or the Supreme Court justices because it is the Supreme Court. I remember we talked about it last class. The Supreme Court is, the Constitution is the supreme law of the land, along with federal laws and treaties. And so any law that goes against the Constitution of the United States or any law that goes against a federal law or a federal treaty will be deemed invalid by the U.S. Supreme Court through the power that they have that is known as judicial review. And Marbury versus Madison is the first case where the Supreme Court recognizes and establishes that they have the power of judicial review. And so what happened in Marbury versus Madison is a very simple situation. Politics has always been important at any moment in time. People have always played political games. They do that today. They did it 200 years ago. And what happened back then is that a gentleman by the name of Marbury was appointed by President John Adams to be a judge. But he didn't submit the paperwork until the last day. And that paperwork was never properly processed. So that when the new president of a different party, Thomas Jefferson, becomes president, his Secretary of State, future President James Madison, refuses to honor those appointments. He refuses to submit that paperwork because, remember, John Adams didn't submit it. He left it to be submitted. But the Secretary of State of the new president, James Madison, refused to submit that paperwork. And what comes into contact, and so as a result, James, Marbury never gets a chance to become a judge. So Marbury sues because he wants to become a judge and he wants James Madison to respect what John Adams had previously done. And so when Marbury sues, what Marbury sues about is he claims that the Supreme Court has been given by Congress a power to force Congress in these circumstances to get involved, or to force the president in these circumstances to get involved and honor the appointments that were made previously by a previous president. And so he claims that Congress gave that power to the U.S. Supreme Court in the form of a law. And so He wants the Supreme Court to look at the law. He wants the Supreme Court to use their power that was given to them according to Marbury by Congress to force Congress and the president to honor the appointment of Marbury as a judge. And so the Supreme Court looks at this law and they, for the first time ever, do this whole judicial review thing. What does that mean? Well, they look at the law and they decide that it's not valid. They review the law and they say, hey, listen, us justices, we realize that this law gives us more power, but this law violates what the U.S. Constitution says are the Supreme Court's powers. And because it violates the Constitution, the law must be declared invalid. Therefore, we don't have the power to do this, Mr. Marbury, and as a result, you will not become a judge. And so while the Supreme Court, interestingly enough, decided that they didn't want to keep this power that Congress had given them, so they're losing a little bit of power there, they did so in exchange for the much greater power. They argued, and correctly, that the Constitution of the United States gave federal courts to review laws and decide whether they violate the Constitution or not. And that's what judicial review is, the power that courts have to review a law and decide whether it conflicts with the U.S. Constitution, okay, or federal laws or federal statutes, anything that's, anything that's according to the Constitution. Now, we can divide, generally speaking, laws in many different ways. One way that we can divide laws are whether the law is a criminal law or a civil law. What is a criminal law? What is a civil law? A criminal law is a law that, or when you break a criminal law, let's phrase it differently. When you break a criminal law, what that means is that you have wronged society as a whole. And so society, in the form of the state government, wants to punish you for the wrong that you as an individual have inflicted to all of society. Civil law, on the other hand, is when there is an issue involving two individuals. It could be more than two individuals, but it's a much more individual affair. It's about a business with another person, or a business with a business, or a person with a person. And so the people involved are individuals, because one individual claims that another individual has wronged them. Okay, and so that is civil law. Okay, and we can label criminal laws by their types. There's different types of criminal law: murder, rape, robbery. We can label civil law by different types. Tort is a type of civil law. Okay, that's personal injury, when somebody harms you because maybe you went to Walmart and it was wet, the floor was wet, and there was no sign saying that it was slippery when wet, and you don't realize that it's slippery, you fall, crack your skull, you're suing Walmart because you weren't warned that the floor was wet and that you need to be extra cautious. That's an example of a tort. But torts fall under the broader category of civil law, because civil law could also be an issue with a contract, right? I agreed to sell you 10 koala kickballs for $100. You give me the $100, I don't give you the 10 kickballs. You sue me because you want me to honor what I said in the contract. And that's not a tort, that is a contract issue. But it falls under the broader category of civil law. Again, two individuals having a problem with one another. Now, there is sometimes an overlap between criminal law and civil law, meaning that the same story can have a person breaking a criminal law as well as a civil law. The PowerPoint presentation uses the example of a DUI. Somebody driving behind the wheel drunk gets into a car accident and severely injures, let's say, Joseph. And that is a criminal issue, because society as a whole is wrong when people are driving drunk, and that is punishable by society towards the individual. But it also involves a civil law issue, because Joe can sue the driver for the damages, the pain, the medical bills, the repairing of the car, and the lost income that Joe has suffered. Whatever losses, financial losses that Joe has suffered as a result of this DUI driver, Joe can recover and sue the driver to get money back. and that becomes a civil law issue. So the same fact pattern, the same story, has a criminal law case separate from the civil law case. There are two different cases, two different judges, two different trials, they don't mix, but it's the same fact pattern, it's the same story. I want to talk very quickly about what a legal citation is. A legal citation is, we can think of it as the address of finding an opinion, an address where we can find the legal opinion a judge wrote in a case, where the judge makes up or adds to part of the law. Okay, so think of it as a street address. If somebody were to tell you where is Los Verdes and Pines, okay, well, you guys might know where Los Verdes and Pines is because there's only one Los Verdes and Pines. And so maybe the name alone might give you an idea of where to go. Well, if it's a very famous Supreme Court case or a very famous court case, all I have to do is type in on Google the case, and voila, Marbury versus Madison is here, right? Like if I just type in Marbury versus Madison, it's very easy because it's a very well-known case. But what happens when it's Garcia versus Hernandez? Well, when it's Garcia versus Hernandez, there have been a lot of Garcia versus Hernandez cases. And because there have been a lot of Garcia versus Hernandez cases, the result there is I need a specific address to figure out whether we're talking about the Garcia versus Hernandez in Miami Beach, in Miami, in Orlando, in Tampa, or in LA, right? I need to get more information. So that's where these street addresses come into play. So we can think of legal citations as street addresses, right? Where we can specifically find the location of a specific case, and what a judge wrote was the law, the case law in that specific case. So it has three basic parts: a volume number, an abbreviation for the title, or we can think of it as the title of the book, and a page or section number. I don't need you to know the different parts of a legal citation for this class. I just want you to know what a legal citation is. A legal citation is a street address. So if I right now were to copy and paste this information right here, and I were to put it and search for it in Google, Miranda would pop up because that's a street address for Miranda. And so whenever you, as a lawyer, you want to make sure you always learn how to discover these, learn how to find these numbers, because they are gold. That's where you're going to be able to find the case law, the opinion, where the case law is written. And that's going to be very important. All right. And I've been mentioning this word opinion. And again, I tried telling that a legal opinion is where the judge writes out in 1, 3, 5, 50, 100, whatever many numbers they want, the outcome of a specific case. And that's where the case law is going to be found. And a legal opinion is going to have 5 components to it. It's going to have the facts that led behind the case. So it's going to be basically like, hey, what's the cheese? What's the deal? What's the problem in this case? What happened? What are the facts? It's going to provide what the legal questions are. What are the legal problems of the case? Okay. It's going to have the law that we know may be relevant for purposes of understanding the case. And then it's going to have the holding. The holding is going to be the decision that the judge makes. And the decision that the judge makes is going to either agree with, we call that affirm, go against, we call that reverse, or change, or remand. Remand means I'm going to let the lower court decide this. Any one of those 3 decisions are what the court could do to decide the outcome of the case. And remember, in this context, opinions are written by appellate court judges. And we're going to get to explaining what appellate court judges are, but it's not written by the trial court judge. It's written by a judge like a Supreme Court justice who has received the case, and they are looking at the appeal and trying to figure out which way the case should go. Okay. And so That's the holding. The holding is going to be the outcome, the ruling of the case. We agree, we disagree, or we kick back to the lower court for a decision. That's the holding. And last but not least, the argument, the explanation for why the appellate court judge reached the holding. And that's the last thing that we're going to see. I don't care about case briefs. I'm going to skip along. I've already talked about citing a case. Jurisdiction is an important concept for you to understand. Jurisdiction means that a court may only listen to a case that they have the power to listen to. Meaning, the state of Florida, let's say that in Miami, there's a Florida judge in Miami. The Florida judge is not going to be able to make a decision on what Georgia law is because he does not have the jurisdiction, the power to listen to those types of cases. Okay, and that's jurisdiction. Now, there are 3 tiers of judges in both the state and federal levels. So with this 3 levels at either tier, what they are is the trial court. That's where you have the jury, you have the witnesses, you have the facts coming out, and the jury decides whether the defendant is guilty or not guilty if it's a criminal case, or liable or not liable if it's a civil case. That's the lower court. That's a trial court. Then there's an appellate court. The appellate court is the court where you listen to those appeals, where there's an appeal. And the appeal is always going to be made because one of the sides, the losing side in the lower court, argues that the judge misapplied the law, that there should be a change in how the law is understood, that the law is wrongfully being implemented. And they want to make sure that the appellate court judge fixes the problem of law because the loser in the lower court at the trial court level says that the wrongfully applied law has impacted the loser negatively. And maybe they would have won the case had the law been properly applied. And then last but not least, there is an appellate court above the appellate court. We call that the Supreme Court. In other words, the Supreme Court gets to decide final appeals, but it's very hard to get to the Supreme Court. Okay? And so these 3 levels exist to make sure that if either side thinks that the rules are being violated in the process of the trial, they get to have their rights restored if that did happen. Okay. I'm going to skip this. So these remember that I said there's levels within the 2 tiers, right? The state court tier and the federal court tier. Here are the 3 levels. The lower courts in the state. In Florida, we call them county courts or circuit courts. The intermediate appellate courts. In Florida, we call them the district courts of appeal. And the state supreme courts. In Florida, we call them the Florida Supreme Court. The same tiers, the same levels, I should say levels, the same levels also exist federally. We have the U.S. District Courts the U.S. District Courts. These are the trial courts. We have the U.S. Circuit Court of Appeals. These are the intermediate appellate courts. We also have the U.S. Supreme Court, and that is the final court of appeal. That's the final Supreme Court. Officers of the court, okay, so different people, you might want to know this. Lawyers are officers of the court, so I'm an officer of the court. A judge is an officer of the court. A clerk is a clerk being the people who help the judge write the opinions and get ready on a day-to-day basis. They're officers of the court. And the law enforcement officials who protect the courtroom, whether they are a sheriff, a marshal, a bailiff, whatever they are also officers of the court. Now, these concepts are very important: standing, mootness, and rightness. Okay. In order for a case to be heard by a judge to see whether a lower court messed up, the party involved must have what is known as standing. Standing means that you actually were the person who was wrong, and there's actually been a wrong that's been committed towards you. So if Florida today were to pass a law outlawing gay marriage, I would only have standing to sue the state of Florida if I wanted to get married to another man. Because I don't want to do that, because I'm heterosexual and I want to get married to women, it wouldn't affect me. I wouldn't be able to have standing before a court to request that law gets changed. Okay, I would have to be somebody that's been impacted by the wrong. Because I'm not personally impacted, I would not have standing. Mootness is when you have to make sure that the issue is still present in order for the court to take it. So what this means is, okay, so imagine that you are a high school senior and it's March 2021 and you are suing Madder Lakes Academy because you are arguing that the school's uniform policy violates your First Amendment freedom of speech rights. Okay, so you do have standing at that time because it affects you, right? You are a person that's affected. However, if the court listens to the case in July, it is now a moot issue. What does moot means? It no longer matters to you. Why not? Well, because if they listen to it in June or if you listen to it in July, you graduated. And therefore, whether the issue was wrong or not wrong, it's irrelevant because it no longer, while it may have at one point, it no longer affects you. So you have to make sure that the issue is not moot and still applies to you. Ripeness is the other problem. So like mootness is the problem no longer exists. Ripeness means the problem doesn't yet exist. So if you're a fourth grader and you want to make the same argument, you want to make the same lawsuit, you can't do that because you're not yet being impacted by Madder Lakes uniform policy. You can only do that once you become a sixth grader. Because you're a fourth grader and Madder Lakes does not have fourth graders at the school, you are not negatively impacted by Madder Lakes rule that the school uniform policy. You have to have a school uniform policy. The fourth grader is not impacted, therefore the issue is not ripe. Think of it like a banana, right? You only eat a banana when it's ripe. You only have a court case when it's ready. Because the case is not yet ready, the court will not listen to it. And that's it for today. That's pretty much today's lecture. If you guys have any questions, feel free to reach out to me, message me, whatever. And I look forward to seeing you guys next week. Make sure you guys stay on top of those assignments. Stay safe. And goodbye, everybody.